And we are live. Welcome to Atlanta's newest homeowner live stream. My name is Matt Martin. I'm your host, and this community is dedicated to helping as many people as we can achieve the dream of homeownership. So each week I bring you helpful videos, tips, and live interviews with professionals around Atlanta to help equip you with the knowledge, tools, and relationships you need to become Atlanta's newest homeowner. So don't forget to hit the like and subscribe button for more content like this. And today I'm joined by Bohn. Hello, Ann.
Hey, Matt, how's it going?
Doing good. So Ann is a real estate attorney at Grace Chun Associates. So welcome, Ann. Could you tell us just a little bit about your business and how you help first-time homebuyers?
Well, we've been doing closings for first-time home buyers for over 20 years. So we are very responsive to questions. I love helping people buy their first home. It's
Awesome.
always emotionally satisfying for us.
Awesome. So a lot of first-time homebuyers, actually, I'm sure 100% of first-time homebuyers don't realize this, but every real estate transaction in Georgia has to be closed at an attorney's office. Is that correct?
Yes, yes.
Yeah. So I've heard that back in the day, you could close at a Waffle House with just a notary, and those days are long gone, I think. So, um,
I
so,
haven't heard
uh,
about those too often.
so what a lot of first-time homebuyers don't realize is that when you put an offer on a home, so we talk about making offers on homes all the time, but you're writing a contract. So on the offer, they'll sign their side of the contract, and they're hoping that the seller agrees and will sign the other side of the contract. So, since it is a contract, can you help us break down just some important parts of the real estate transaction?
Well, one thing you really want to know is all the terms that you're offering when you're the buyer in the contract, because once the seller signs it, those are the terms you're committed to. So you want to read over the offer with your realtor and learn the terms and timelines. There's a lot of timelines based on when you inspect, if you have due diligence, when you can get in to do the appraisal, etc. So get with your realtor and really understand the paperwork you're signing, and that way you won't miss any deadlines.
That's right. Yeah, absolutely. So there are important terms and timelines throughout the contract, and that holds to both parties. And another thing that a lot of buyers don't realize is that there is a spot on the offer page on the contract where they choose the real estate closing attorney. So that's another member of a real estate team for first-time home buyers. So there's your realtor, there's your lender, there's home inspector, there's all those things. But a lot of people, if they're new to home buying, they don't really have a relationship with a closing attorney. But your name is somebody that they could write in on that spot, right? And they
Oh,
could
absolutely.
have you be the closing, overseeing the closing for them. One question I think it's important for first time homebuyers to know is earnest money. There's just so many terms that get thrown around, and a lot of first time homebuyers don't really understand what it is. So could you just explain a little bit about what earnest money is, who holds it, how it can be lost, and maybe how much it should be?
Okay. Well, earnest money is an amount of money you put on your offer that you're willing to deposit with either the buyer's agent, the seller's agent, or the closing attorney's office to show the other side that you are committed to buying the property. A lot of times, between 1 and 3% is fairly normal. So if you're buying a home for 300,000, you would typically put up 3,000 to 6,000 to $9,000 on your offer, and then make arrangements if the offer is accepted for it to be deposited with the earnest money holder as stated in the contract. Frequently, as closing attorneys, we hold the earnest money, so you'll wire in or you'll bring over a check to our office, and we hold those funds. And if for any reason the contract doesn't end up closing, then based on the terms of the contract, we decide who gets the earnest money, whether it be the buyer gets it back or the seller gets to keep it. And it's based on the terms of the contract. So, like if your offer says there's 7 days due diligence that the buyer gets the benefit of, then during those 7 days, you can inspect the property. Maybe you find something, okay, I don't want to buy the property after all. If you terminate before the end of your due diligence period and you do the proper notice as the contract stipulates, then you get the earnest money back. But if you wait until day 28 and you're about to close and before you decide that, hey, I don't think this house is right for me, then you risk losing the earnest money unless there's some other term in the contract that allows you to get that back. So that's why when dealing with earnest money, it's very important to look at the dates, see what you're dealing with regarding inspection or due diligence or financing contingency or appraisal contingency. See if you're inside any of those dates so you can get your funds back.
Right. Absolutely. Yeah. So the earnest money functions in two ways. One, it helps kind of signal to the seller that you're very serious about purchasing this home, right? And it can also be a penalty for you if you don't perform your end of the contract, right? So it's important for home buyers to pay attention to that because, for a first-time home buyer, $9,000 is a lot of money, and you want to make sure that you're upholding both the parts of the contract that you're responsible for. Otherwise, you could be in breach of contract. So could you explain a little bit about what breach of contract might look like on maybe both a buyer and seller side?
Okay. Well, if a buyer were not to actually buy the property, maybe they can't get their loan approved, and so they can't perform, then that can be breach unless there is a financing contingency that allows them the time they need to, if they get a turn down, then if they have a financing contingency and they're still in that time period, then they can keep their earnest money by following the terms of that financing contingency and giving the other side proper notice. But if they wait until that period has expired, that would be an example where they would probably be in breach of the contract if they didn't buy the house. And then in that case, the seller would probably get to keep the earnest money. All these are very SPAC specific, so you always read your contract carefully to make sure you're operating in good faith, in compliance with the terms of the contract.
Right, absolutely. So I heard you mention contingencies a lot, and those contingencies are common, but they're also not standard, right? It depends on what is written specifically into your contract. So some of the contingencies are due diligence, which is, the time period where a first-time homebuyer could inspect the property and, negotiate for repairs or, threaten to walk away. And they're able to walk away without penalty, without losing that earnest money if they do that during that due diligence window. But there's a couple other contingencies. Could you name a couple more for the home buyer?
Well, the appraisal contingency is another possibility. So if you add that to your contract that the house has to appraise for the sales price, and it comes in lower than the sales price, then based on the appraisal contingency, you negotiate either the seller will lower the price or perhaps the buyer will decide, I still want the house and pay the difference. Or the buyer might have the opportunity to decide, well, since it didn't appraise, I would like to back out of the contract. That would be like for an FHA, they allow you to back out of the contract if the house doesn't appraise for sales price, if you're using that type of loan product for one.
Right. Yeah, so I like to say that contingencies are just these little windows in the contract where you can escape if you need to, and they're important for protecting the buyer. And unfortunately, over the last 18 months, a lot of buyers were felt like they needed to waive a lot of those contingencies just in order to get the deal, but they really opened themselves up to trouble in the contract because they had no way to get out if, for example, the contract price was way above the appraisal price. So that's just a few of the things as far as contracts go. But there's a lot more to the legal side of real estate, and one of those is title. So there's chain of title, cloud of title. There's owner's title insurance. There's all these kind of things. So could you just explain for a little bit what is title and why is it important when you're buying a home?
Okay, one of the things the closing attorney does, one of the main things, is we research the title for the property you're buying. So we make sure, for one, that the people who are selling it to you are the people who actually own it. And then we also check to see what mortgages may be against the property. Are there any taxes that are owed? Are there any judgments against the sellers that need to be paid at a closing? Are the sellers getting a divorce? Are the sellers did one seller pass away? Now the surviving seller is selling. So all of that is covered by our research when we do the title exam. And then we go over it to see what issues need to be cleared up so that the buyer has good title. And that we get all the documents we need signed at closing that can be recorded at the courthouse to show now John Smith is the new owner instead of Jimmy Jones. So we go through those processes. We check to see what issues need to be addressed, if any. We reach out to the seller and the listing agent if there's any questions about anything showing up on title or any documents we need to obtain in addition that we don't normally get. So that is a big part of what we do as closing attorneys. Also, you asked about owner's title insurance. That helps, and about the vast majority of folks, when they buy a home, do get the owner's title insurance because it protects you against things that even might not show up at the courthouse. If there's been a forged signature in the back chain of title, that's something even the most perfect title exam can't tell. And so having that first title policy, for one, helps you in those situations. But there's a lot of other title issues. One real common one is an open loan deed, where somebody has paid off a mortgage, but it's still showing as if it's open at the courthouse. The cancellation never gets to the courthouse, so there's not proof there that it's been taken care of. So then what we do as closing attorneys is we go and we research those issues and try to get additional documentation to show, in fact, that loan was paid off, so we don't have to worry about it at closing. But owner's title is a perfect way to protect against that type of issue too.
Right. Yeah, a lot of those things are kind of just in the weeds, and you kind of just hope everything works out. But that's why I'm grateful for title companies and attorneys to help make sure that my interest in the property is protected and that I actually own what I paid for. It would be a nightmare scenario to have somebody, a distant relative from the past, make a claim on your home, saying that they have a right to it. So that's kind of the chain of title, and also and those kind of things. But how would you recommend home buyers take title to their home? So there's a couple different ways that they can take title. Is that correct?
Oh, absolutely. And there's more, but the two major ways that buyers tend to take title are in Georgia are tenants in common and joint tenancy right of survivorship. And the differences between those two are joint tenancy right of survivorship means, and typically this is a married couple will come in and they want this. That means if one of them should pass away, the other owner becomes immediately the owner of all the property upon the death of the other. So the two people own the property, one passes away, the surviving person owns all of the property immediately. They don't have to worry about probate. Even if the will of the person who passed away says the property goes to somebody else, it doesn't. The joint tenancy right of survivorship trumps even something in a will that says something different. So that's how the vast majority of married folks handle things in Georgia. Because they want to save their spouse the time and effort of going through probate in order to prove they're the owner through the will of the spouse. Now, the other way is tenants in common. And a lot of times if two partners, investors, let's say, want to buy a property and they're not married, they just happen to be business partners buying an investment, they'll tend to buy as tenants in common, which means each person has a percentage ownership, typically 50% ownership each in the property. If one should pass away, then that goes through their estate rather than immediately to the other owner. So if their estate says that 50% interest goes to their spouse or their children, then that's how it would be instead of going to the other partner. So those are the differences, and we're always happy to answer questions at or before closing to let people know about that so they can make an informed decision.
Right, absolutely. And I think it sounds like such a simple thing, and usually I think they get asked at the maybe a couple days before closing or at the closing how they wanted it to be handled, and in most of the time they're kind of caught off guard. I would say that the right of survivorship one is a really helpful benefit for married couples. It's also a little bit of the what's yours is mine and what's mine is yours kind of reality, is that you're both full owners of the home, but it would also save your spouse a lot of heartache and headache if and when you pass away, that they're not having to go through legal hurdles just to refinance the house or any other thing that they might need to do. And for instance, I was helping an elderly gentleman sell his house, but they had taken title as tenants in common, and so he owned half and his deceased wife owned the other half, and so we had to probate her estate just to get the permission to be able to sell the house. And so that made the sale take months longer, and so that was a bit of a challenge. So it sounds like something very simple, but it's a great benefit for the right situation. So well, good. So another thing that comes up, so we hear a lot about due diligence and inspections, and usually there's a little bit of a song and dance in getting the seller to either contribute cash at closing that will be used for repairs or whatnot, or sometimes the seller to repair things on the home. And so what happens in when you get 2 days from the closing and those repairs didn't get handled? What's the best way to make sure that repairs get done on time? What kind of stipulations should be in place so that they're enforceable when it comes time to close on a house?
Well, one thing we've talked about is that if you have a repair that isn't done at closing already by the seller, that repair does not survive the closing if you just proceed. The normal language does not allow that to survive the closing. So you would not have the benefit of the contract promise to enforce in a court if you don't take further steps. So ideally, When you're writing the special stip and the seller has agreed to make a repair, I like to have at least 5 business days ahead of closing for inspection of the repair. It's, don't just say to be completed at closing. I would suggest the repair needs to be completed 5 business days prior to closing. And that way it can be inspected. And then if there's any issues, they can be fixed and you can still make your closing date, hopefully, depending on the type of repair. So try not to let it be that the repair can be done up until the last minute, because then that puts the buyer in a weakened position.
Yeah, that can lead to a lot of drama at closing when you go for the final walkthrough the day before and all of the things that the seller had agreed to do haven't been done, and then you're stuck with, oh no, they seemed like such nice people, and then they didn't do, the $5,000 worth of repairs that they were supposed to do. So it's important when signing those amendments that the stipulations are clear, who's doing the work, how it's being done, when it's supposed to be done, and what proof can be provided that it has been done correctly. So if those things aren't done, then you can threaten to delay closing. Is that right?
Well, part of the closing is that stipulation. So yes, if the seller is not living up to the stipulation, they can be held in breach. So, but since most people want to be able to buy the property, that's why they put it under contract. By doing the inspection a few days beforehand and not waiting till the day of closing, hopefully it can be done in a way that makes everybody happy. Another way to deal with it, depending on your loan underwriting, is instead of asking for a repair, asking for closing costs. And that way, if you've gotten estimates and you think that the repair is going to be X dollars, and you haven't used up all the potential for closing costs paid by seller based on underwriting, so you have to be in conjunction with your lender as well as your realtor on this in coordination, then asking for closing costs to help offset that expense might be the way to go. So then you can handle the repair after closing and know it'll be done in a way that satisfies you.
Right. Yeah, and this is just one of those areas that can get real tricky too, because it's like if the seller doesn't perform the way they say they perform, they're supposed to, and you close, sometimes your only recourse from the small claims court, right? So. Yeah, so you could sue, you bring a lawsuit to the seller for a few $1,000s, but I think most people kind of do the cost calculation of is it really worth pursuing these things. So as great as contracts are, they're really only as good as the people in the contract, I feel like. So that there's unfortunately some.
Absolutely. Yes. You want to make sure. And if you do allow a repair to be made after closing, if you say, I need to be able to move in, perhaps the buyer's already got their stuff on the truck, but they find out the day of closing, they do the walkthrough that something hasn't been completed. And maybe I would suggest this more for smaller things rather than larger things. You can do a contract amendment that allows an extension of time, but obviously the negative to that is if you've already closed, your leverage against the seller to do the repair is reduced dramatically, and the expense of going to court about it obviously makes it impractical in a lot of ways to pursue certain things after closing. So obviously the best way is either let them pay closing costs for you if you can, or be able to inspect it several days before closing. So you're not on the moving truck needing to close.
Right. Yeah, it can get, the timelines can get very stressful if you're moving out and needing to move in certain times. And yeah, it's an emotional roller coaster buying a home and having to deal with negotiations. And a lot of times tempers, can get flared between both buyers and sellers. And that's why it's helpful to have some cool heads in the process to help things prevail. Well, Ann, you've been a great help for us in talking through some of these things, and it sounds like it would be a great opportunity if a home buyer has questions about particular things that they could give you a call and reach out to you. So what's the best way that home buyers could get connected with you?
Well, I'm here at Grace Chun and Associates, and our phone number is 678-324-8852. So just reach out, give us a call, and I'd love to talk with you.
Awesome, thank you. And your name and company is very Googleable too. But I also made sure to drop your contact info in the comments on these platforms. So, and thank you so much for joining with me today. Once again, my name is Matt Martin. If you'd like to get started on the path to home ownership, give me a call or drop a note in the comments. I'd be happy to follow up with you and grab coffee. And also, I just want to say to the Atlanta's newest homeowner community, your feedback and comments are an important part of helping this community grow. And I want to hear from you. So if you have a question or a topic suggestion, please drop it in the chat. And be sure to connect with us on social media by hitting the like and subscribe button. But thank you all for joining.
Thanks so much, Matt.
Thank you.